So I'll be simulcasting, and we are live both there. And so let me say hello to Carmen and to Moegshiena.
Hi, everybody.
I don't know if
Hi,
Moegshiena is
Marco.
there.
How, Musila? Can you hear me?
She's hiding. She's hiding from us.
She's hiding.
Yeah, we don't want to
I
show her
told
face today.
mm, she's
But
just
no
checking.
worries, no worries. It's good to have you ladies on board, of course. And Carmen, when I asked that question about Christmas music, what did you say?
Absolutely not. Go for it.
So
I
it's
pulled
not
my
too early.
Christmas news out already. It only comes, I've
Ah,
got it in the car, so it comes out once a year. And I was also
okay.
thinking, as I wait for the 1st of December, I thought, ah, man, it's just a week away. Why not?
So I'm waiting on the listeners to let me know how they feel about it. But also, Moegshiena, welcome to you. We've missed you, seeing that we're doing this new thing, yeah, virtually. I know. I don't want to be on the other side of that where Moegshiena knocking something. But while we're waiting on Moegshiena, especially on the audio, I'm not sure what's happening over there. But let's talk about maybe this is a continuation of last week, Common, and we spoke about landlords, we spoke about rights, and today we're gonna go a little bit deeper. And so maybe I'll start with you and asking about the key elements every landlord should include in a written lease agreement for a smooth tenancy. And so hopefully we can get Moegshiena also to answer some of the more technical questions. But let's start with that question.
Okay, so when I look at a lease agreement, there we go. Hello. It's just your sound now. Camera's there. Ooh, and now Marco's also gone. Anyway, so the everybody's hiding away from me, and it looks like I'm still alive. Okay, so your sound
I'm
there.
very, very nervous for the camera today. No, no, I'm not sure about Moegshiena. I can't hear her. I can see her
Yeah.
now,
Uh,
and she's not muted. So I'm not too sure what's happening over there. But let's continue with that question for now. Let's see if we can sort Moegshiena out in the meanwhile. But let's get into that question about the key elements every landlord should include in a written lease agreement.
Okay, so first thing I will look at is the 4 Ps, and that looks at number one, the parties. So, who is the parties that are involved in the lease agreement? Normally, it's the landlord and the tenant, and we need to be very clear to see who the landlord is, that it is the registered owner of the property, and then the tenant needs to know that they are taking responsibility for the lease agreement, legal and financial responsibility, because often we have times where perhaps the occupant, for instance, cannot afford the rental on their own, and they will get a what we call a guarantor to come on board with them. And if they're also signing as the tenant, they need to understand they're taking full responsibility of the lease agreement, both financial and legal aspects. So it's parties, then it's property, the full description of the property. So we often find ourselves in situations now where we've got multiple dwellings on a property. So we might have a separate entrance or two, making sure that we are specific what area of the property that the tenant is leasing, if there's more than one dwelling on the property, and also if it's in a community scheme, then we also need to make double sure we're clear on that. But either way, we need to identify the property that's been let. Then we need to look for payment. So payment would be what the monthly rental is going to be, right? Um, the rental amount, of course, is determined normally as estate agents. We would provide a recommendation to the landlord, and the landlord would then make a decision on the rental amount that would be charged. So that would be payment. And then, of course, payment terms as well. So payment terms would be: is it going to be weekly? Is it going to be monthly? What date it's going to be made, etc. And then, of course, payment methods. Um, Electronic transfer is the best form of paying rental these days, because if you do any other forms of transfers, such as cash or even via a Yoko machine and those kind of things, it attracts charges or bank fees. So those are the things, the main things that we look at, is parties, property, payment, payment terms and payment methods. And of course, there are other material terms that we would add on to that as well.
And so we're glad to see Muhsina is back with us. Can you just say something to us there? Say hello to us.
Hi. Can you hear me as
Okay, there
well?
she is.
Yeah.
Yeah, we can, yeah. So there she is. Happy to have you on board, of course. And also,
Thank
if you're
you.
following us on Facebook as well as YouTube, you can pose your questions there. And so, if we have time, we can answer that. And as well as on WhatsApp at number 0617981075. And then we've waited for this lady, and now she's got to step into the breach here and answer some questions. So, we're talking about today. The key elements every landlord should include in a written lease agreement for a smooth tenancy. So, Muhsina, can you shed some light on how a well-crafted lease agreement protects landlords legally, and also what pitfalls rather they should watch out for?
Sure. Look, there are fewer regulations in terms of how to draft a lease agreement versus the sale of a property agreement, for example, right? So basically, you do have free will when it comes to your lease agreement, provided that it's still compliant with public policy and that nothing in the lease agreement is unlawful. So let's say, for example, you put a clause in the agreement to say that if the tenant defaults on rental, you're going to kick them out. Unfortunately, that is unlawful. You're not permitted to do that because you can never ever take away the authority of the courts to declare whether someone has defaulted on their rental and whether someone needs to vacate your property. It has to follow a lawful and legal process in order to evict someone. So it's considerably important because a lease agreement will make away with disputes between the landlord and the tenant, because you can put in mechanisms either to mediate or conciliate between the parties. And the courts love it when you mediate and you conciliate before you actually approach a court. And if there is obviously any other type of dispute that needs to be resolved, you can permit parties to consent to the jurisdiction of a lower court. So maybe instead of going to the high court, which tends to be more costly, you can both consent to go to the magistrates court, which tends to be a little bit more cost effective for the landlord. And obviously, if your tenant also needs to then get legal representation, it makes it better for them in terms of the cost efficiency of the whole process. So basically, it comes down to literally just avoiding disputes, and in the event that there is a dispute as to the terms of the lease, that your lease agreement, if it's drafted well enough, will make provision for how to resolve the disputes between parties.
Okay. So it's good to, like I said, have you on board, and we waited. And thank you so much for all of that great advice there. I'm going to get to you in a couple of minutes or so, but let's talk about, Carmen, how crucial are regular property inspections, and what are the best practices for landlords to ensure the condition of their properties?
Okay, so not only is it good business practice, but it's also required by law. If you look at the Rental Housing Act, the Rental Housing Act prescribes that there should be a joint move in inspection and there should be a joint move out inspection. And when we're saying joint, it means each of the parties need to be represented. So a representative or the landlord himself of the landlord, and the tenant themselves or a representative of the tenant. And the move out inspection is crucial because we cannot do a deduction from the tenant's deposit if there are any damages to the property during the lease period, if we don't have a joint move-in inspection and a joint move-out inspection, because we need to marry the two and then also check what has been the changes during the lease period, fair wear and tear accepted, and only based on that are we then allowed to take deductions from the tenant's deposit. At Meraki, we also encourage what we call an interim inspection. So we don't wait until the move in inspection to visit the property. We look at the interim period during the lease agreement, generally around midway of the lease, so that at the midterm inspection, we can get an idea of what to expect by the time we reach move out. We can then also forewarn the tenant and say, if you're planning to move out, these are the items you need to look at. Give them an opportunity to sort it out before the move out inspection to avoid deductions on the deposit. And then it also helps the landlord to make a decision that if the tenant is interested in renewing the lease, will we go for a lease renewal or not? Because, I mean, a good tenant doesn't only pay the rent on time and accurately, they also look after the property. So it also helps the landlord make a decision then on, based on our feedback, whether a renewal would be applicable or in order.
I'm so glad that we can cover a lot of these type of issues, especially last week we spoke about how emotional it is,
Mm.
especially for those renting or even for the landlords, and how difficult it is um, to get to resolutions when there are disputes. So I want to bring Muhsina in again, and in the event of a dispute, how can landlords protect the interest legally, and what steps should they take to resolve conflicts with tenants?
Yeah, so look, so if you are a landlord and you are facing issues with your tenant, whether it's default on rental, whether the tenants just become abusive in the sense that they're not permitting you to conduct your regular inspections, or they're treating you badly, they're basically bullying you, the first point of contact is always an attorney, right? Because we obviously are your foothold between you and your tenant, and the law and the legal steps you need to be taking in order to legally basically vacate the tenant or to resolve whatever disputes you have ongoing with your tenant. Generally, if a tenant is in breach of their lease agreement, either they've stopped paying their rental and they've now just full on become squatters in that sense, and they've stopped paying the rent, the first thing that we need to do is we need to send them a letter of demand, and we give them a period of time within which to comply with that demand. So either to settle the rental in full, alternatively, the landlord does have the recourse to just let the tenant go. So that is basically to cancel the lease agreement and then to advise the tenant that they need to vacate the property within a specific period of time. The termination of a lease agreement is never fault based, right? So basically, a landlord doesn't need to wait until the tenant is in breach of the lease agreement to cancel the lease. A landlord is entitled to do that whether or not the tenant is at fault, with one exception though, and that is if the property gets sold, a landlord is not automatically entitled to let that tenant out of the property. Okay.
Okay.
And this again comes back to having a very well drafted lease agreement, because the only way you can allow the landlord to vacate, to basically make sure that the tenant vacates the property in the event of a sale of that property, is to make sure that the lease agreement caters for that event. So the lease agreement will say that in the event that the landlord has opted to sell the property, the tenant will be required to vacate the property in accordance with the required notice that has been given. That is because we have a constitution and our law gives preference to someone being in a home. So if there is a lease agreement on a property and the landlord chooses to sell, he cannot just tell the tenant, look, you need to move out because the property is now on sale. The lease agreement needs to cater for that to happen. And if the lease doesn't cater for that to happen, the buyer has to buy that property with a tenant in it. Okay. So everything comes down to drafting your lease agreement very well. And then if there is a dispute, the first thing you do is you'll first try to resolve it amicably with your tenant. If you don't see that there's a way forward, then you would consult an attorney, and the attorney would draft the necessary letters. And then if the tenant does vacate the property as required in terms of our notices, we will then commence the eviction proceedings. And that can take anywhere between 6 to 8 months Sometimes a year, sometimes maybe more, depending on how cooperative the tenant is, and depending on whether or not there are any delays in the eviction process.
So I know you said quite a mouthful, and when it comes to legal stuff, not all of us like to hear certain things. But I want to pose a
Yeah.
question to both you ladies, seeing that you deal with it on a daily basis. So let's talk about just quickly some of the common things when it comes to disputes that you guys come across. Um, and I know, like I said, we always hear different versions of stories, but in terms
Mm.
of rights, in terms of what you normally hear. What are those common things?
Rental. The payment of rental often comes across my desk. And I also just maybe want to just to give tenants a heads up, right? Sorry, Carmen, if I may be cutting you off, but sometimes your landlord has purchased the property and they've bought it with a bond, right? And you might feel that the law does cover you. It does cover you. It gives tenants a considerable amount of rights. But I just want to let you know that if you ever find yourself in a position that you are unable to pay your rent, I would rather just go to my landlord and negotiate that rather than to leave your landlord on the back foot, in the sense that if you don't pay your rental and landlord is relying on you paying your rent so that he can cover the bond, not only are you putting your landlord on the back foot in the sense that he now has to pay out of pocket for that bond, he also has to pay out of pocket for the maintenance, the insurance, the upkeep of that property. So your conduct also has a knock-on effect on your landlord. Yes, you might be in a certain predicament, but also put yourself in your landlord's shoes. I know it is not always a very, how can I say, sometimes it's not a friendly relationship, but I would rather go to my landlord and renegotiate rental if I foresee myself not being able to afford it, rather than to just stop paying
Mm,
rental, staying in the property. Your landlord's already on the back foot because they need to pay a bond every month and they need to spend additional amounts of money in order to evict you from the property, essentially. And I mean, evictions can cost anywhere between 12,500 to 50,000 to 100,000 rand.
Mm.
So maybe just pay heed to that as well. Yes, the law does protect you. There is a legal process that your landlord must follow. I'm not saying that it's ever right that your landlord just come knock on your door and put your things out on the street, but also maybe just take a more nuanced approach in terms of
Yeah.
what your landlord might also be facing when you just decide to stop paying rental as well. And
okay.
then one last thing, I just want to say, as a tenant, you can never stop paying your rental if there is a defect in the property. So
Mm.
let's say, for example, the taps are leaking or the shower is broken or whatever it may be, you cannot simply withhold your rental based on that fact. You also cannot pay a reduced rental amount based on that. You actually have to approach a court to do that. Best case scenario is just to get your landlord in to have it fixed. And if you've maybe reached your last straw, and you can perhaps prove to a court or at the end of this that you've spent X amount of money in maintaining it, that cost your landlord to repair, and he hasn't, or she hasn't, then
Mm.
your landlord must compensate you for those damages. So that's just a little bit on my side in terms of what crosses my desk the most, and also what tenants also need to take into account when they start sitting fast or knocking their heads with their landlords. Okay.
Yeah.
So briefly, Coleman.
Oh, from my side is I often like the first thing people will come to me with disputes or scenarios, and the first, how do I handle this? How do I handle that? My landlord gave me notice, or my tenant didn't pay, or the landlord didn't fix the tap. Different scenarios, and my first question will always be, what does the lease say? So the lease is always
Mm,
going to be our first point of reference, because you can't give advice or guidance if you don't know what the lease is saying. So that's why it's so critical that you've got a written lease agreement in place. And I often get the feedback of, no, we had a verbal agreement. I've been there for 8 years. I've been there for 9 years. Or no, we were friends. We are close family members. No matter how close that family member or friend is to you, get the agreement in writing.
Yeah.
I have to like just highlight that it's important. Written agreements are important because that's always going to be the first point of reference, whether it's myself, the attorney, or the courts that is looking at the dispute. Um, get it in writing. I tell you, we have the best relationship with some tenants when they move in at the move in inspection. Good relationship during the lease. You get to the move out inspection and you have to do some deductions, and that the relationship can flip like that. And the same thing between a landlord and a tenant. So, in order to protect relationships, make sure you've got written agreements in place.
Hmm.
Sure, there's so many things that I still want to ask, but we're running out of time. I blame Muhsina. It's always her, always her. But it's always great to have you ladies on board, of
You
course.
spoke a lot, sorry.
Um, no, no, no. That's very, very important information. Also, just letting you know, we are podcasting these episodes, as we call it. So you can go check it out on the app as well, because a lot of people asking us a lot of questions, and also where can we take a listen to the podcast. So we are making it available now. I had to ask some more questions, but I'll leave it to you, Carmen, just in terms of what we may not have covered today because we're running out of time. Well, what is it that you still want to mention to the listeners?
From my side, as an agent, I often experience that some landlords feel they don't want to spend the money upfront to pay perhaps for a commission or even for rental management, because they feel that then the net rental is going to be less than what they expected. But if you invest that money upfront to get a professional like us to handle the service, then it can save you lots of pennies down the line. Because if you don't follow processes properly, if you don't do your letter of demands properly, and all of those legal processes follows the initial lease agreement. So if that lease agreement is not in place upfront and it isn't done correctly, then it does cause complications further down the line if they need to take the matter into a tribunal or even to the courts.
Rosina?
Just a note on verbal lease agreements. If your lease agreement is verbal, it basically we consider it a month-to-month lease agreement. And if we issue you with a notice to vacate, we are only supposed to give you 1 calendar month to move. So just be wary of that. You can reduce your lease to writing at any time during your lease agreement. So if you are a tenant and your lease is currently verbal, speak to your landlord, reduce it to writing. And of course, if you are a landlord, reduce that to writing as well. So that's just a bit more on my end. Yeah. I will mainly come in when Carmen starts complaining that the tenants have defaulted, or when the landlords need to cancel the lease, then I will come in. But yeah, by all means, do get a managing agent. You definitely need one.
So, ladies, just contact details. I've got Carmen's details on the screen at the moment, but maybe she can just verbalize it for you. I'll get Muhsina's details on screen as well for those who are following us on Facebook and YouTube.
So 079 495 7358. I repeat, 079 495 7358.
Also, just Muhsina, I've got your numbers on screen or your details on screen. Not sure about that email address. Maybe you just can confirm, and then we're gonna say goodbye.
Sure, not a problem. My office number is 021 201 6828. That is 021 201 6828. And the email is correct. It's info@ishmaelinc.co.za. Thank you.
These ladies are sharp, and I'm getting better at getting all of the details to you. But I want to apologize to everybody sending messages on WhatsApp. There's a lot of them coming through. Um, Carmen did promise we're going to have a show just for you with all of your questions because we see there's a big need for it. Delisha also says, loving this program. It's very informative. Thanks, guys. And that's the feedback we've been getting from a lot of the listeners is that it's been very informative. So we've covered the landlords. We'll cover a lot more of the other topics as well, as said by Carmen and Meraki Property Solutions. And also with thanks to our favorite attorney. That's a new title. Our favorite attorney, Moegshiena
You're
Ishmael.
welcome.
So with that,
You're
do we
welcome.
say goodbye till the next time, ladies? Thank you for being with us today.
Thank you.
Until next time, cheers.
Okay.
Thank you. You're
Okay.
welcome.
Goodbye.
Bye.
They don't look like they want to go, but they got to go.
We don't. We actually like this.
Sit and I like both. But with that, I say goodbye to you, ladies. Till next time, cheers.
Bye.
So those were the ladies of Meraki Property Solutions, and with that, I gotta get to some music and ending the stream.